Your Lordship,
Yes, please.
I beg to mention item number 16, Your Lordship.
Item
16.
once, please.
Yes, sir. Will be taken after the break, Your Lordship.
After?
Break. After the puja break, Your Lordship.
Oh. You are the counsel for the,
1 and 3, Your Lordship.
you are the counsel for the,
1 and 3, state respondent, Your Lordship.
oh, one and
Yes, Your Lordship.
respondent 1 and 3.
Yes, Your Lordship.
On the prayer of Mr. Swenson. The learned counsel for the respondent number 1 and 3. Listed after 3 weeks.
Oblige, Your Lordship.
May I please, my lord?
Yes, please.
My lord, I beg to mention one unlisted well applications. for
What is
today.
that?
Antiseptic well, my lord.
What is the urgency?
My lord, since it's an antiseptic well application, case is registered and
Listed tomorrow.
my lord, in this matter, Lanet senior counsel coming from Guwahati High Court and he will appear the matter. I'm just authorized to mention the matter, my lord.
Listed tomorrow. We'll list it, we'll take up tomorrow. Okay.
My lord, matter already filed, my lord.
Yes, so file, so let them list it tomorrow. It's not listed today. Let them list it
My lord,
tomorrow.
it's a last item, my lord.
List it tomorrow. Okay, list it tomorrow. Yes,
Vice.
May I, Your Lordship?
yes, please.
My Lordship, even I am moving for the unlifted matter.
What is the urgency?
Urgency is a bail cancellation. And
It's what?
it's a rape case,
It's a bail matter.
bail matter, but
hear it
for the
tomorrow.
bail,
We'll hear it
bail
tomorrow.
cancellation.
We'll hear it tomorrow.
Okay.
Okay.
The lawyers from the Guwahati party
It's all right.
have
They
already
can
arrived.
leave anywhere. We'll list it tomorrow.
Oh,
Okay, we cannot give them special privilege.
okay.
Everybody's same.
Yes.
As a lawyer, everyone is same.
Okay.
We give them equal privilege. List it tomorrow.
Oblige, Your Lordship.
Yes.
May I, lordship?
Excuse me. This can be. A little. Not much. Thank you, sir. Yes, please. Yes.
My lord, my lord, my lord, accused person arrested on
This is what is your petition
the
about?
bail petition.
Bail petition.
Yes.
All body case there, Your Lordship. It's
Yes,
a 413 and regular bail application.
2023.
Pertains to NDPS case. Your Lordship.
Okay. Heard Mr. So-and-so. The learned counsel for the applicant. The present application has been filed under section 439 of the CRPC 1973 for granting bail to the accused applicant in connection with PSA PS case number 15/2023 under section 21 within Regel B 27 of NDPS Act 1985. Call for the case diary. Listed on.
Ninth, Your Lordship.
9th.
Yes.
9th of October.
October, yes.
Listed on 9/10/2023. Yes, please.
Petitioner is unrepresented, your lordship, and however, this is a joint petition, your lordship. So matter may be taken up after a week, since they have not appeared today,
Oh,
petitioner.
the counsel for the petitioner.
Yes,
is-
yes.
Okay, okay. None appears for the petitioner. Listed after a week.
Obliged.
Yeah, please, madam.
Yes,
My lord, I'm appearing for respondent number two, my lord.
you are for
Private respondent number two.
private respondent number 2.
Yes, my lord. My lord, the petition is
And
not. here, my lord.
you are the Leonard PP.
Yes, yes, yes.
What about the petitioner?
So here, SIP.
Yes, I think private, private,
Your
private.
lordship, I'm appearing for one.
So may I humbly pray the matter may be fixed after the puja break, my lord.
Appearance from petitioners.
None appears for the petitioner. Yes,
Malata, subject to your lordship's convenience, otherwise I'll pay for disposal of this,
disposal.
subject to your lordship's convenience.
Will it not be necessary for the state and for the respondent number 2 to file your affidavit? Will it not be necessary? Not. Okay. What is the matter about?
My lord, this is a order passed by the ADC executive magistrate, which is put under challenge, my lord. Supposedly under a 145 CRPC, section 145 CRPC proceeding, my lord. The order.
Let us see 145
Yes.
CRPC.
Under this provision, my lord, this is basically for maintaining the public peace and tranquility, my lord. Now he has touched into the rights on a title basically, and the order itself is contradictory to itself. Whereas the finding is based on an order passed by the deputy commissioner. And the deputy commissioner has decided on the rights on the title. Rights
Let
of
us see
title.
the impugn order.
The impugn order, my lord, is at 18, page 18, my lord.
Page
18, my lord, 18. And one of the grounds that have been urged here is that the executive magistrate has failed to derive any satisfaction that there was a likelihood of breach of peace. And in a very mechanical manner, my lord, that this order has been passed.
Where is the operative portion?
Operative portion, my lord, is at page 19, my lord. Page 19, my lord, last paragraph, my lord, starting from last paragraph. And perusal of records, my lord, it is found that Deputy Commissioner White, his order number so and so dated 11/1/2023, wherein the application of Trichy Murgi HGB model village for modification of LPC of Sri Likha Sahib White number so and so was rejected on the ground that the final cost value of the land has been paid by Sri Likha Sahib, and claiming of the plot after 18 years of physical possession by Sri Trichy Murgi seems to be illogical. The learned DC court, while dismissing its representation, has also advised the complainant That is, Sri Tishi Murgi is at liberty to approach the appropriate court for his grievances. From records, it is also found that by order number so and so, the Assistant Commissioner Naharlagan has directed so and so to remove the illegally erected pillar post from the plot of complainant within 7 days. From the inquiry and by examining the parties and the evidences adduced by the parties and as per the records available, and being satisfied by due inquiry head thereupon, without references to the merits of the claim of either of the said parties to the legal right of possession, then the claim of actual possession by Sri so and so is the respondent matter is convincing. I should decide and declare that he is in
Who is this Karanzol? Karanzol?
Ranjal Kohli is his respondent.
He is the respondent.
Yes, in this revision petition.
So he seems to be in possession.
That is what. So further, my lord, should see, my lord. I shall decide and declare that he is in possession of the said land located and so, and entitled to retain such possession until custody, until ousted by due course of law. And Sri so, he's the son of the petitioner herein, my lord, is directed to remove all structures whatsoever constructed, erected inside the disputed plot within 1 month from the date of receipt or order, so and so.
Yes, you have, by this order, you have given the liberty to approach the appropriate forum.
Yes, my lord. My lord, firstly, my lord, this order of 11/1/2023 that I have also annexed, my lord, where the deputy commissioner, without any jurisdiction, my lord, he also decided in that.
Do you mean to say that this additional deputy commissioner has no jurisdiction?
He has jurisdiction, but when he relies on the order of the deputy commissioner, my lord,
No,
of the 11/1/2023, my lord.
he has also given independent observation.
No, my lord, that is why, my lord, that is also contradictory, my lord. He says the respondent is in possession and directs me to remove the structures, my lord, my structures from the land, my lord, from the disputed land, which is itself contradictory, my lord. If I have my structures on the disputed land, it means that it is in my possession, my lord. And the order, my lord, one another aspect is that he has never tried to derive any satisfaction as to the likelihood of breach of peace, my lord. Without that, he could not have initiated this proceeding in the first place, man. Because the complaint was filed by the respondent number 2 before the deputy commissioner, saying that your order of 11/1/2023, it has been violated, my lord. Basically, it was more like an execution filed by the respondent number 2, my lord, because it is in my possession, my lord. So he writes to the deputy commissioner that your order of 11 January 2023, man, it is not been followed by the petitioner, man.
Let's see that 11.
11/1, my lord, is at page 30, man. Annexure 7, man. Annexure 7, my lord. This is this starts with my complaint, my lord, and he has decided on the issue of the title itself.
Who is this Teki Murki?
Techi Murgi is the petitioner, my lord.
He is also the head GB.
Head GB, my lord. Head GB of the Naharlagan, my lord, or model village Naharlagan.
And this Teki Murki, is he the person who had actually purchased the land from you?
Well, he's in.
How is he in the picture?
My lord, he is the petitioner, my lord.
That's why.
The
What is
Techi
it?
Murgi, he is the petitioner, and
He is the petitioner.
yes, ma'am.
What is his role in the case?
My lord, basically there was a dispute, my lord, with one Likhasaya, my lord, regarding a land, plot of land. I sold the land to him, man, in the year 2004, man, but he did not make the full payment, my lord. So my dispute was with this Likhasaya, my lord. And while I was having this issue with this Likhasaya, my lord, he gifted it to the respondent number 2, my lord.
And respondent number 2 is?
Respondent number 2 is Kranjal Kohli, my lord. So basically, this complaint I had filed before the deputy commissioner saying that the LPC issued to Likhasaya should be cancelled, my lord. And then I came to know only during that time that he has gifted it to respondent number 2 in this petition, my lord. So he also appeared, my lord, at serial number 4, your lordship will see, my lord.
Now, who is this Teki Murki? What is his role?
my lord, he is the owner of the land, man.
Oh, he is
He's
the
the owner of the
land.
land.
He is the one who had purchased the land from you.
No, no, my lord. My lord, I am the Tichimurgi, I am representing Tichimurgi, my lord.
You are
Yes.
representing?
Tichimurgi, my lord.
He is the owner of the land.
Yes, my lord.
The land, my lord.
Oh.
Techimuki had sold that land to one Likasaya, my lord. And Likasaya gifted that land to me, my lord. Now that land is in my possession, my lord. Now, thereafter, what happened, my lord? His son encroached upon my land. So I filed a complaint before the deputy commissioner.
You are Karanjal Khole.
Yes, my lord.
And who is Karanjal Khole?
Karanjal Koli has been gifted this land by Likasaya. Likasaya is the one who has brought the land from Techimurki, from the petitioner.
Then why is Lekha Saya not implicated as a party?
He is no more a party, my lord. He has already gifted, my lord. He has relinquished his rights. So now it is dispute is between my lord, respondent number 2 and me.
But actually it is Lekha Saya who should actually prove.
Of course, my lord, but of course, my lord, it would have been in if it's a civil suit, my lord, title suit, he would be necessary party. But here it was only relating to the possession, my lord, section 145 CRPC, my lord. So that's why Likhasaya was not a necessary party. Because this otherwise this order of the deputy commissioner relying on which the ADC has passed an order, my lord. If you also will see, my lord, at page 33, my lord, is a relevant portion, my lord. Otherwise, he doesn't have jurisdiction to decide these issues that the deputy commissioner himself also, my lord.
Why? Why no jurisdiction?
No, my lord, because
Under what
he has
particular
entered into the realm of, my lord, deciding the title, my lord. So he doesn't have the jurisdiction. After the separation of the judiciary, my lord, he could not have passed such an order, my lord. He says, my lord, in the relied on so many things, and the final operative portion, in the light of above facts and circumstances of the case on records, it is observed that there is no any pending liabilities left by Sri Likhasaya as per the money receipts, wherein it was clearly mentioned that the amount received as a final cost of the land and claiming of the plot after 18 years of physical possession by the complainant seems to illogical as the boundary wall has been constructed, and as such, I do not find any concrete evidence in favor of the complainant, and therefore, under the above observations, the instant complaint is dismissed with a liberty to complainant to approach appropriate court for grievances, if any. So he could not have even passed such an order. So this was also even again put to challenge, my lord. This order of the
Why he could, the deputy commissioner could not have passed this order?
because, my lord,
Why?
he has decided the title, my lord.
Where
which-
is the question of title?
my lord,
Where is the question of title? Just show me.
my lord, in
Where
this
the deputy
order,
commissioner has decided the question of title?
my lord, in this order itself, he says, my lord, because he says the Likhasaya has made the full payment, my lord. So basically, what he is saying that when he has made the full payment, my lord, he has the title, my lord, which he could not done. But otherwise, my lord, that order, my lord,
That may be just an observation to decide the case.
no, my lord, on that ground that is in pass. And my lord, this order, my lord, was again put to challenge, my lord. It has been set aside by this.
Basically, your challenge is to the order passed by the additional deputy commissioner.
Yes, my lord. So, my lord, but
So
this,
additional deputy commissioner has given you the avenue to
No, ma'am.
approach the proper forum.
no, my lord, basing on this order, my lord, deputy commissioner, order of the deputy commissioner, my lord, the ADC has passed an order. And this order of the DC has now been set aside, my lord, by this honorable court, my lord.
This,
11/1/2023, my lord. That observations of the findings of the deputy commissioner,
in which proceeding?
11/1/2023, that page 30, my
The
lord.
entire order was not set aside, my lord.
Yes, my lord.
Only
No,
subject to the statement where the money is concerned, my lord.
Yes, my lord.
Page number 32, last paragraph. Where the deputy commissioner stated that the full payment for the lane has been given. Only that part, my lord, was set aside, my lord.
Yes, my lord. This is recently, my lord, this was, my lord, 6 WPC 129 of 2023, my lord, on 6/9/2023.
So regarding the non-payment of money, it has been set aside,
my lord.
correct?
Yes.
So what remains?
So my
What
lord,
is left to be decided in your case?
in this case, my lord, basically the order of the ADC, man, the executive magistrate, man, that is still there, my lord. And that ADC, order of the ADC is passed basing on this order of the deputy commissioner.
So to
Yes,
that
yes.
extent,
That is- yes,
okay,
that
to that
extent-
extent,
Yes, ma'am. That extent to it has been set aside, ma'am.
Ah.
And when the order has been relied, order of the ADC is relied on the order passed by the deputy commissioner, ma'am. It decides on the title
Ah.
of the parties, my lord.
Ah.
And the complaint, my lord. There is nothing, my lord, to show that he has derived any satisfaction. If you also will see, come to page 35, my lord. Page 35, my lord. That is how the section 145 proceeding was initiated, my lord. This is by the respondent number 2, my lord, Kranjal Kohli, my lord. Page 35, my lord. Annexure 9.
Page 35.
Yes, my lord.
What is this?
This is the how the, my lord, this proceeding under 145 was
No,
initiated.
your page 35 is regarding a letter written to the deputy commissioner.
Yes, my lord. After the order of this 11 January, my lord, this Kranjal Kohli, respondent number 2, he files a complaint before the deputy commissioner saying that your order of 11/1/2023 has not been complied with, my lord. So if you also see, it has been marked to ADC, and the ADC mechanically issues an order, my lord, at page 39, man. Whereas it was not about any breach of peace, my lord, apprehension of breach of peace, man. The respondent number 2 says, writes to the deputy commissioner saying,
How do this court decide who is in possession, who is not in possession?
my lord, that proper inquiry has to be done. And before that, my lord, he has to derive satisfaction, my lord. There is a likelihood of breach of peace, my lord. Here the respondent number 2 only writes to the deputy commissioner that your order of 11/1/2023, it has not been followed, my lord. And it is marked to the ADC, my lord. Now ADC mechanically this page 39, my lord. Nothing, my lord. First of all, he has to derive some satisfaction, my lord. There is a likelihood of breach of peace. Just because that order of the ADC is there, he is also following suit, my lord. That if you also will come to 145(1), my lord, whenever an executive magistrate is satisfied from a report of a police officer or upon other information that a dispute likely to cause a breach of peace exists concerning any land or water or the boundaries thereof within his local jurisdiction, he shall make an order in writing stating the grounds of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by pleader on a specified date and time, and to put in written statements of their respective claims as respect the fact of actual position of the dispute, subject of dispute. So he has to be satisfied with it, man. And
So what you mean to say is that this provision was not followed?
no, man,
145(1).
no, man. Because your lordship has seen at page 35, the order of the complaint, man, annexure 9, page 35. It is a letter to the deputy commissioner saying that your order of 11/1/2023, where you said there is no pending liability, it is not being followed, man. That is what the complaint says. It was more like an execution filed by the respondent number 2, my lord. So the deputy commissioner marks it to ADC, and ADC in a very mechanical manner, without any report, without any satisfaction, just issues this order.
Okay,
That is one
to
of
that extent
the,
I have understood. Now give me the gist of your case.
my lord.
Give me the gist of your case.
My lord, that is one.
Give me the
Basic-
facts of your case.
Yes, man. My lord, facts is that in the year 2004, man, I sold the land to one Likhasaya, man.
Likhasaya.
Yes, my lord.
He's
He's not a
not a
part.
party here.
He's not a party here, my lord.
You means the petitioner.
Yes, my lord. Tichimurti, my lord. And there was supposed to be some amount of consideration, my lord. But that was never paid, my lord. I repeatedly approached this person, Likha Saya, he's an ex-MLA now, my lord. At that time, he was he was an MLA, man. He never made the full payment, man. So in the 29/10/2021,
Have you sold him 2 plots of land?
no, only one plot,
Only 1 plot,
one plot, man.
only
That,
1 plot.
yes, man. My issue was with Likha Saya that you have not made the full payment, man. That was the basically the issue, my lord.
Okay.
Now, after that, my lord, when he did not make the full payment, my lord, I made a complaint to the deputy commissioner on 29/10/2021, saying that the LPC land possession certificate, man, issued to this Likha Saya should be cancelled, my lord. And at that time, we came to know that the Likha Saya had already gifted it to respondent number 2, man, Kranjal Kohli, man. Otherwise, Kranjal Kohli is also my clan brother, my lord. We belong to the same clan. Respondent number 2 also, man.
So 2004 petitioner sold the land to Likha Saya.
Yes, my lord.
So once you have sold the land, what is your problem?
Well, that is another aspect, my lord.
So
So,
what is that aspect? Let me know.
my lord, that aspect was that the full payment was never made, my lord. The payment for the entire plot of land, it was never made, my lord.
Okay, so full payment not made, but what happened?
Yes, ma'am. So, my lord, in the year 2021, well, I repeatedly approached my lord, but he never made the payment, ma'am. So I filed a complaint, my lord, before a deputy commissioner because
You were the first person to file a complaint.
yes, ma'am, saying that the land possession certificate issued to this Likha Saya, it should be cancelled, ma'am.
Why?
Because he has not made the payment.
You yourself has raised that civil issue.
My lord, I might have raised, but deputy commissioner could not have. Maybe after 18 years, my long time, there is no ground for cancellation. That could have been done, my lord. That orders could have been, those orders could have been passed, my lord. These are, my lord, petitioners also, my lord. These are all men, my lord. Not
Yeah,
aware.
You could have straight gone to the civil court to
Yes.
resolve the issue.
My lord, when that,
Where is your petition?
that I have
Your
not,
first petition?
is that I have not annexed, my lord, but it can be seen from the order of the deputy commissioner, my lord, where it has been mentioned, my lord, because I have filed, I have not kept a copy, my lord. Page 30, my lord, the first paragraph itself, my lord, that the deputy commissioner has said, my lord.
Submitted by Techi Murki.
Yes, ma'am.
You are this, you are
Yes.
this.
ma'am. For modification of land possession certificate of Sri Likha Saya, was so and so, due to less
For
payment of the
modification
land,
of land possession certificate of
land located
Likha
at,
Saya.
yes, ma'am.
This Likha Saya is the person from whom the respondent number 2 have purchased the land.
Yes, ma'am. It seems so, my lord.
So you made the first complaint.
Yes,
Correct.
this is in 2021,
You made the first complaint.
yes, ma'am. But
Then what was the outcome of your complaint?
outcome, your lordship has seen, my lord, this deputy commissioner has decided, my lord, that Likha Saya does not have any liability, my lord, pending liability, my lord, to the petitioner.
Where is that order?
That is page 30 only, my lord.
Deputy Commissioner.
Page 30, my lord.
Ah,
This is
let's
the,
see the operative,
yes, operative portion, page 33, my lord.
page 33.
My lord. In the last paragraph, my lord, in the light of above facts and circumstances, my lord.
There
Circumstances.
is no any pending left by Sri Lekha Saye as per the money receipt, which was clearly mentioned that the amount received was final
Final
cost
cost
of
of
the
the
land.
land and claiming of the
plot
plot of
after 18 years of physical possession. So this
this,
Lekha Saye,
yes,
what this deputy commissioner observes is that Likha Saye has been in possession of the land for the last 18 years.
Yes, claiming on the,
Correct.
yes, ma'am. And he says that, he doesn't have any pending liability. Likha Saya does not have any pending. Now, this observations, my lord, has been set aside, my lord, that, order I've just provided.
This has been set aside by this order.
Yes, my lord, WPC 129 of 2023, my lord. On 6/9/2023, my lord.
Now let us see this High Court's order. Let us see. Let us come one by one. Let me just understand your case. Which is that operative portion, setting aside this
My lord, your lordship would see paragraph 3 is, my lord.
paragraph 3.
Yes, ma'am.
Okay.
From perusal of the impugned order dated 11/1/2023, passed by the Deputy Commissioner cum District Magistrate Capital Complex, Itanagar, it appears that there is some civil dispute regarding full payment made by the respondent number 4 to the petitioner in respect of the land situated in A sector Naharlagun. It was in furtherance of resolving the aforesaid dispute. It appears that the learned Deputy Commissioner cum District Magistrate Capital Complex, Itanagar had made the aforesaid observation that the respondent number 4 does not have any pending liabilities left, while sending the parties to approach the appropriate court for grievances. Since the Deputy Commissioner cum District Magistrate Capital Complex, Itanagar does not have the jurisdiction to make any such observation regarding the civil liabilities of the parties, this writ petition, with the consent of the learned counsels of the counsels for the parties, is disposed of at the stage of admission hearing, by providing that in the event the parties to the writ petition approaches the civil court of competent jurisdiction for resolving their disputes regarding full payment made by the respondent 4 to the petitioner with regard to the land situated A sector Naharlagun. The trial court shall not take into consideration the observation made by the Deputy Commissioner cum District Magistrate in the order dated so and so in the case of so and so, so and so. Accordingly, it was disposed.
So against the order passed by the Deputy Commissioner, you had approached this court.
Yes, ma'am.
How was the case endorsed to ADC?
ADC, to the ADC, it was
After this
after,
court had passed this order?
no, madam, before that, ma'am.
Before.
Yes, ma'am.
Okay.
This was disposed on, my lord,
By which order it was endorsed?
endorsed, my lord, if your lordship would see the complaint, my lord, at
Ah.
page 35, my lord,
Page 35.
35, my lord. This complaint was made on 31st March 31 January 2023, my lord, by the respondent number 2. ma'am. It was not about any, my lord, this complaint is not about also any breach of peace, likelihood of breach of peace, my lord. Because I continue to remain in possession, my lord, the petitioner, my lord. So he makes a complaint, my lord. Respondent number 2 makes a complaint to the Deputy Commissioner.
Yeah, what is actually the complaint? Let us
Yes,
see.
ma'am. Intimation regarding deliberate violation of the order dated 11/1/2023 and to initiate necessary action thereof. ma'am.
Ah,
Yes, ma'am. So DC has said that those persons does not have any say liabilities, anything, and that's why. But I continue to remain in possession, so that's why this complaint has been lodged, saying that although you have passed an order, saying that the respondent, my lord,
this application by the respondent
yes,
does not disclose about the breach of peace.
no, my lord.
Just read the complaint, let us see.
Yes, my lord. It is, it's a long one, my lord, 4 pages.
Hmm.
That with due respect and humble submission, I beg to state that I am the absolute legal owner and in possession, it should be possession, my lord,
Okay.
possession of a plot of land measuring about so and so square meters situated. The said plot of land purchased by Sri Likha Sayan. That it may be informed that to you that as per the due procedure norms, the land possession certificate for the said gifted plot of land was procured by Sri Likha Saya with so and so dated UPI so and so from the office of the deputy commissioner so and so. That sir, it is pertinent to state and submit that while the said plot of land was in peaceful possession without any hindrance and encumbrance from any party on 29/10/2021, after a gap of more than 17 years, Sri Techi Murphy filed a complaint praying for modification of the land possession certificate issued by the so and so dated so and so on the ground that the full payment of the said plot of land was not paid to him. That to my utter dismay, Sri so and so, son of so and so, resident of so and so, started to encroach upon the said plot of land. As such, I filed a complaint before the office of the Extra Assistant Commissioner Narlagan, whereupon on, if you're just pausing here for a moment, the complainant itself, he says, my lord, the petitioner and his son has encroached upon the land in the year 2022, my lord.
Started to encroach
Yes.
upon the said land.
Yes. I will show the complaint also. my
Started
lord.
the pro-
He has already filed a complaint in the year 2022 saying that they have encroached upon the land. By this itself also, it's very clear that I am in possession, my lord. The
As
respect,
such- As such, I had filed the complaint
yes,
before the.
complaint
deputy
before the office of the EAC Naharlagan in March 2022, my lord, this is. The respected extra assistant commissioner.
Yes.
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 The respected extra assistant commissioner Naharlagan, along with the OCPS Naharlagan, had personally visited the disputed site and found Sri so and so is my son, my lord, son of the petitioner, my lord, making demarcation on the disputed land, and the executive magistrate directed Sri so and so to remove the newly demarcated boundaries till the matter was resolved between the parties, which was duly agreed upon by him and immediately and there in presence of magistrate. Further, the respected EAC come executive minister also pleased to direct both the parties to maintain status quo till the matter is resolved and prohibit any activities and or any activities to be carried out within the disputed land. And if any party violates the order, the police was at liberty to initiate action against the defaulter. That, however, despite the said executive order, Sri so has again encroached upon the said plot of land by digging a canal through JCB in my plot of land, which is a deliberate violation of the executive order that so and so passed by the extraction. That pursuant thereto, I have filed an application dated 6/12/2022 before the executive, before the extra assistant commissioner Naharlagan, intimating him about the violation of the order dated so and so, and to initiate appropriate legal action against the defaulter. That despite numerous complaints and applications, Sri so and so has not refrained from his illegal activities. As such, on 11/2023, when the matter was called upon for hearing before the court or respected deputy commissioner Itanagar Capital Complex Itanagar, after hearing all the interested parties, the learned deputy commissioner Itanagar Capital Complex, its order number so and so was please dismiss and reject the prayer of complainant. The order your lordship has seen, my lord, 11/1/2023. That pursuant thereto, in accordance with the order dated 11/1/2023, passed by this honorable court, EAC Naharlagan, with its order number so and so dated Naharlagan, the so and so, directed Sri Techi Talumtara, son of so and so, to remove the illegally erected pillars posts from the plot of land belonging to the undersigned within a period of 7 days from the date of issue of the said order. That, however, despite the said order dated 7/1/2020, 17/1/2023, even after a passage of 8 days, the illegally erected pillars post was not removed from the said plot of land by so and so, the son of so and so, president of so and so, which is still violation of the direction passed by the honorable court. That as such, finding no way out, on 25/1/2000, I had again submitted an application before the PSC Naharlagan intimating the non-compliance of the order dated 17/1/2023, and further requesting his Benin office to allow me to remove the illegal pillars post on my own expense and to deploy adequate police personnel for security reasons. That person there to on 28/1/20, I removed the illegal pillars post from the said location without any hindrance or disturbance from any order. However, to my utter shock and surprise, the very next day, Sri Tichi Talum Tara had again illegally encroached upon my plot of land. In this regard, it may be informed that Sri so and so has not only encroached upon my land, but he had also demolished the concrete wall of my plot of land, which is constructed about so and so big. Further to aid to my agony, Sri so and so even illegally constructed a kacha hut within the vicinity of my plot. That it may be worthwhile to state here and that all these illegal activities were carried out in presence of so and so, head GB model village so and so, father of so and so. Sri so and so is the petition, my lord. Being the head GB of model village and being a responsible person ought to have precluded the violators from carrying on their illegal and malicious activities. However, on the contrary, he was the one who encouraged the impugned illegal activities. That, sir, I desired to reconstruct the concrete wall which was demolished by Sri so and so at my own expense. However, in an event, I might have reasonable so and so might interrupt, obstruct, create an which in turn may result in description of law and order situation. Be that as it may, sir, I have submitted numerous applications to the concerned authorities for granting relief to me, but time and again the same has been denied me. In fact, the action impugned in this instant application is expressly malicious, contemptuous, and needs to be dealt with iron hands. As such, I humbly pray before your honorable court to interfere and grant adequate and efficacious relief to me, lest I shall suffer irreparable loss which cannot be compensated in any term. Therefore, under facts and circumstances as aforesaid, I most humbly pray your honorable court to take my humble application under your kind consideration, evict the encroacher from my legally possessed plot of land, allow me to construct the concrete wall demolished by Sri so and so. In such an event, direct the OCPS Narlagan to deploy adequate police personnel for security.
So consequent to this application, the deputy commissioner has decided the matter.
Yes, the
Correct.
DC now has marked it to the ADC, my lord. I do not know whether there is any order or but on the complaint itself, page 35, my lord.
You were actually making a submission that the ADC had passed the order on the basis of the order passed by the deputy commissioner.
Yes,
So where is that order of the deputy commissioner?
that order of the deputy commissioner, your lordship, 11/1/2023, my lord. Page 30, my lord, which this court has already, that operative portion, this court has said aside.
No,
Yes,
I just want to know the sequence of your case.
yes.
So this operative portion set aside by deputy commissioner.
Yes, ma'am. Basing on this order of the deputy commissioner, ma'am.
So the application in the who is this?
Kranjal Kohli, ma'am. The
The
respondent number two.
respondent number 2.
Yes, ma'am.
In the application dated 31/8/2023.
31/1, my lord.
31/1, okay.
Yes.
That stated that actually the petitioner has violated the order passed by the deputy commissioner.
Deputy commissioner, yes. After that 31/1 order, my lord, or 31/1 this application complained by the
Well, what is the date of the ADC's order?
ADC's order is my lord, 9/3/2023, ma'am.
9/3.
2023.
Why did you not take up this issue in the same rate petition 129/2023?
My lord, because when this was passed, my lord, when this writ petition was filed, at that time the order of the this ADC was not there, ma'am.
ADC was not.
Not there, ma'am. And otherwise, if your lordship would,
Notice of the extra assistant.
after this
Take me again to that order passed by the ADC.
ADC, my lord.
Take me to that.
Yes, my lord, after that complaint, my lord, the first order was at 28th February, my lord, at page 39, my lord.
This is by extra assistant commissioner.
Yes, ma'am. No, my lord, page 39, my lord. After it was marked to the ADC, my lord.
Ah.
Yes, ma'am. Now, how he derives the satisfaction regarding the likelihood of breach of peace, my lord.
30.
Page 39, my Annexure 10, my lord.
Additional.
Yes, ma'am. ADC come executive magistrate, my lord. This is where is report has been submitted, ma'am. Your lordship will see, ma'am.
This is the only order passed by
No.
ADC.
This was the initial order, my lord. Then subsequently, there is an order of 9th March, my lord.
This is-
After it was marked to the ADC by the DC, my lord, he says, order under section 145, my lord. Whereas a report has been submitted by Sri Kranjal Kohli regarding here also he says, ma'am, regarding deliberate violation of order dated 11/1/2023, passed by the learned Deputy Commissioner, Capital Itanagar, in the matter of land dispute at A sector Naharlagan in between so and so. It starts with the violation of the order only, my lord, of the order passed by the Deputy Commissioner. And whereas so and so, ma'am, yes, mentioned in the second paragraph. And there is nothing, mal, no inquiry, nothing done, mal, on the basis of that complaint letter, mal. He says, and whereas I have an apprehension that the dispute is likely to cause breach of peace exists concerning the disputed land. Mal. Now, therefore, taking into account, I see Jiken Bomjan, so and so, come executive magistrate cabinet, exercising powers conferred upon me under section 145 CRPC, do hereby order both the parties to maintain status quo at the disputed site. Further, both the parties are directed to appear before the undersigned in person or through a pleader on 9/3/2023 at 1100 hours for hearing of the case.
But the order of status quo
Man.
does not prejudice you.
No, man, I continue to, yes.
If you are in possession,
Yes, ma'am.
it is in fact in your favor,
Yes, ma'am.
the status quo order.
Yes, ma'am. Now, after this, my lord, that it was fixed on 9th of March 2023, ma'am. And that is the impugned order, ma'am.
Yes, please, yes.
What can be seen from this order also 20th February 2023 at page 39.
So after this, which order has been passed?
9th of March 2023
And it is in which page?
at page 18, my lord. Otherwise, your lordship has seen, my lord, this order, there's no exercise, nothing.
Page.
Page 18, my lord. 1/8. This is the impugned order, my lord.
This is passed by additional deputy commissioner.
Yes, my lord. The same authority, my lord. Additional Deputy Commissioner Jiken Bomjan, my lord.
This
ADC
is
come,
1311.
no, my lord, this is
Nine.
9/3, my lord.
So this is the impugned order.
This is the
This is the
impugned
impugned
order.
order.
Yes, ma'am.
Okay.
Now he has actually he is supposed to only decide on the factum of the possession, madam. But your lordship will see, he has gone into the entire history, payments, non-payment of the land, and then page 19, madam, from where the operative portion starts.
But this order was passed subsequent to the order passed by this court.
This, no, my lord.
ADC.
ADC, my lord,
ADC passed the order subsequent to the order passed by this court on 6/9/2023.
no, my lord, this
Oh,
is
6/9, okay, okay.
September, my lord, and order, impugn order is from March.
Okay, so when ADC passed this order,
My lord,
6/9/2023 was not there.
not there, my lord. This writ petition WPC 129 was disposed on 6th September, this few days back only, my lord.
Yes.
Yes, my lord.
Okay.
Now, the perusal of the order, the entire order itself would show, my lord. There is no exercise to find out, man, whether there is any likelihood of breach of peace. There is not an exercise to decide who is on title, man. That inquiry is not done. He has basically carried out the exercise to determine the title itself, man. Regarding the payment, non-payment, everything he has decided, man. The amounts that have been paid and the operating portion at page 19, my lord. He,
Yes, wait.
yes,
Yes, which page you are referring?
page
Which page?
19, my lord, the last
Page,
paragraph. My lord,
which page?
page 19, 19.
Okay. Paragraph.
Because I will not bother your lordship with all the.
No,
yes, my-
there's no question of moderation. You have to read. Let us
My lord,
see.
this
Let's see
entire
the impugn order.
impugn order, my lord, it starts at page 18, my lord.
Read.
It appears to me on the grounds duly recorded that a dispute likely to induce a breach of peace existed between Sri Kranjal Kohli and Sri Tichi Murgu of Model Village Naharlagan concerning certain possession and claim of ownership of land between the complainant and the respondent above named located at A sector Naharlagan measuring so and so square meter, which was gifted to Sri Kranjal Kohli by Sri Likhasaya, white so and so, dated so and so, 2015, my lord, bearing land possession certificate number so and so, dated so and so, and the ownership that the said land LPC land is disputed by the respondent Sri Techi Talumtara on the ground that Sri Likhasaya has not paid the balance additional amount for the total area of his father Techi Murge by the previous owner, that is Sri Likhasaya, and claiming hence the ownership of the plot is still under him. The parties involved in the dispute were called upon to give in a written statement of the respective claims as to the fact of actual possession of the said disputed land at A sector Naharlagan, measuring so and so. The respondent verbally submitted that previous landowner, Mr. Likhasaya, to whom his father, Sri Tichimurgu of Model Village Naharlagan, has given the land for consideration of rupees 32 lakhs only on 24/2004 for an area measuring 10 bhighas, that is so and so, which is equal to 13,400 square meter, and the amount for the balance area was never paid to his father, and hence he is claiming the ownership of the disputed land. Meanwhile, the plot has been transferred to Kranjal Kohli by Sri Likhasaya, that on 11/1/2023, the learned Deputy Commissioner Itanagar has passed order whereby Sri Tichi Murge was directed to remove the illegally erected pillars posts from the plot of land belonging to Sri Kranjal Kohli within a period of 7 days. After expiry of the said period, Sri Kranjal Kohli has approached the EAC Naharlagan on 25/1/2023, intimating the non-compliance of the order dated 11/1/2023 by Sri Tichi Murge. And on 28/1/2023, Sri Kranjal Kohli has removed the illegal pillars post that was erected in the disputed plot by Sri Teji Talumtara on 20th. On the next day, the response is that so and so demolished the concrete boundary wall of his plot, which was constructed so and so back, and constructed a kacha height and thereby illegally disposed him from his land. During hearing, the counsel of Sri Kranjal Kohli submitted that it is a decided case in the case of learned Deputy Commissioner Itanagar. In the operating part, he submitted that Sri Likhasaya, from whom his client had brought the plot, has also paid for additional land by paying rupees 5 lakhs only, in which the final deed also mentioned of the final payment. Further, he claimed that the said land is in adverse position as it has been under possession of his client for over 18 years. Sri Kappa Kohli, father of Sri Kanjal Kohli, stated that the wall around the plot was completely erected by him. The wall, which was constructed 17-18 years ago, was removed by the other party. Sri Tichi Talumtara submitted the order dated issued by the Naharlagan under section 133 CRPC should be called back, cancelled as the said dispute is on a private property, not a public property, which is not an ingredient or attracts 133 CRPC. And actually, the Kohli party destroyed the wall erected by them. Sri Tichi Murgu, HGV, father of Sri Tichi Talumtara, submitted that he engaged two renowned persons with so and so, that then GB so and so to settle the pending payment of his land with Sri so and so, but of no avail. Further, he also sent one of his relatives from Yajali, the then ZPM, to Sri Likhasaya, who also fell. In 2015, Sri Kanjal Kohli executed a gift deed with Likhasaya, which is equivalent to 18,860 square meters of land, and accordingly is in excess occupation of the land. Sri Tichi Talumtara and so submitted that order passed by the learned Deputy Commissioner Itanagar has been done without taking cognizance of their submission. Sri Likhasaya has paid so and so for 10 bighas of land, which is not equivalent to 18,860 square meters. However, as per existing rate, then the land should have been 13,400 square meters. Accordingly, Sri so and so has earmarked the land and the excess land has been taken under his possession. Sri so and so also tabled two LPCs, one of Sri Likhasaya for an area measuring so and so, dated so and so, and another LPC was so and so, dated so and so, in favor of his father Sri Tichi Murgu for an area measuring 48,600 square meters. He submitted that the excess land has been given to Kappa Kohli from his land. Sri Kappa Kohli submitted that the learned disease order to be
Who is
executed.
this Kappa Kohli?
He is father of the respondent number 2, man.
Father of the respondent number 2.
2, man. So what basically, yes, I had earlier also made a submission, man. When they made a complaint before the deputy commissioner, it was more of an execution of the order of the deputy commissioner. Now also from here also it is clear, man. Sri Kappa Kohli submitted that the learned disease order to be executed, man. The act of Tichi party is challenge to disease order. There are many residents in the obstructed it would affect the so and so. The Tichi party submitted that the separate entry exit to the plot by the Kohli party should maintain from their own side so and so. And Sri so and so submitted that money receipt was done fraudulently as he was asked by so and so to sign in a blank stamp paper stating that his PA was not available then, and later on it shall be printed. This is the only exercise, madam. And now he comes to the finding. On perusal of records, it is found that Deputy Commissioner by this order number so and so dated 11 January 2023, wherein the application of Sri Tichi Murgu's HGV model village Naharlagan for modification of LPC of Sri Likhasaya, white number so and so dated so and so, was rejected on the ground that the final cost value of the land has been paid by Sri Likhasaya, and claiming of the plot after 18 years of physical possession of Sri Tichi Murgu seems to be illogical. Learned DC court, while dismissing his representation, has also advised the complainant Sri so and so is at liberty to approach the appropriate court for his grievances. From records, it is also found that by order number so and so dated 17/1/2023, the extra assistant commissioner Naharlagan has directed Sri Tichi Talumtara to remove the illegally erected pillars posts from the plot of the complainant within 7 days from the inquiry, and by examining the parties and evidences adduced by the parties, and as per the records available, and being satisfied the due inquiry head thereupon, without references to the merits of the claim of either of the said parties, the legal right of possession, that the claim of actual possession by Sri Kanjal Kohli is convincing. So I decide and declare that he is in possession of the said land located in A sector Nagaland, entitled to retain such possession until ousted by due course of law. And Sri Tichi Talumtara is directed to remove all structures whatsoever constructed, erected inside the disputed plot within 1 month from the date of receipt of the order, and to strictly forbid any disturbance of his possession in the meantime. So this is the order. Now, my lord, my grounds, my lord, basically, first ground is that, my lord, that ADC, my lord, while initiating a proceeding under section 145, my lord. He has not carried out any exercise or inquiry, man, to determine, man, that there is a likelihood of breach of peace, man, as required under section 145(1). The respondent number 2, my lord, he writes a complaint basically for execution of the order, man, passed by the deputy commissioner, man. On 11/1/2023, my lord, that the deputy commissioner passed an order. And on 31st March or 31st January, he writes to the deputy commissioner, the respondent number 2, saying that your order has been violated. It needs to be executed. Now the DC marks it to the ADC, and ADC in a very mechanical manner at page 39, the order, initial order, my lord. He says, there's nothing, my lord, he doesn't know, say how he derives the satisfaction. He only says that I have an apprehension. And then this order, impugn order of 9th March 2023, my lord. There also, my lord, the recording, my lord, it says, shows, my lord, the respondent 2 and his father, my lord. They are praying for execution of the order, my lord. This is order. Now the deputy ADC, my lord, when he relies on the order passed by the deputy commissioner regarding the liabilities, my lord, he has entered into the, my lord, realm of, my lord, right of title, right in title for possession, which he could not have done. And secondly, my lord, he says, my lord, he gives a direction to the petitioner saying that you remove your structure now. You remove your structure, and when he says you remove your structure, well, it clearly shows that it is in my possession now. Now, my lord, to show that, my lord, otherwise, I would like to take your lordship to page 24, my lord, just for once, my lord.
24 of your petition.
Yes, my lord. Yes, 24.
What is this?
This is a complaint by the respondent number 2, man. We made a complaint before the deputy commissioner on 29/10/2021, and since there was no response, my lord, we had taken the position of the excess land, my lord, not the entire land, my lord. Now the respondent, my lord, he writes a complaint, and it was received on 24th February 2022. He says that complaint regarding land encroachment. I beg to state that I so and so, a resident of model village so and so, had bought a piece of uncultivated measuring an area of so and so with some additional land at A sector model village so and so. Today, while visiting the sector, I was shocked to notice that one so and so, son of Tichi Murgimal, the petitioner Hinman, illegally entered in my site of lot and started construction of fencing post inside the compound without my consent. My plot is already covered with boundary walls in all fold. Therefore, I would like to kindly request your good self to register this complaint for lead encroachment and trespassing, and further request you to kindly vacate them from my property at the
Now,
earliest.
just for my knowledge, see, just for my knowledge. You had actually sold the land to the respondent. Okay. You have sold the land to the respondent,
One, not the respondent, madam.
not the respondent, but okay, let's
Okay,
call him the
yes,
respondent. You have sold the land to the respondent.
Ma'am.
And you have been paid 32 lakhs.
Madam.
Now, what is the other problem?
No, my lord, for 32 lakhs,
These are all facts, see, these are all facts which
No, no.
actually I'm not able to still do, I'm not able to grasp.
my lord, that 32 lakhs, it was for certain amount, a certain area, my lord. 13,000 square meter around.
32,
It was for around 13,000 square meter, man. Now that person whom I sold, my lord, he took possession of the 18,000, my lord.
for this 32 lakhs was for
13,000 square meter. man. That-
13,000,
Yes, man.
square
Square
meter.
meters, man.
but respondent took possession.
Of 18,000. It is reflected in order of the DC also, my lord.
Of 18,000 square meter.
Yes, ma'am.
I think I will have to tell you all to give me a gist in writing of the facts. Because your facts are all,
Of course. The
okay,
facts, well, basically is that, my lord, Now your lordship is saying at page 24, my lord.
So your case basically is that by the impugned order passed by the deputy commissioner, it has not passed, it has not complied with the provisions of 145.
145, my lord. Because the complaint filed by the respondent to is of your at page 24, my lord. At page 24, my lord. In the year 2022 itself, my lord.
34.
24, my lord.
24.
Yes, ma'am. It was on 24 February 2022 when he initially made the complaint that the respondent has, a petitioner has taken possession. Since then, I have been possession. And in his complaint also, my lord, to the deputy commissioner, where he says violation of his order. He writes to the deputy commissioner. At paragraph 4 also, he has admitted that I had encroached and I have taken possession, my lord, in 2022, my lord, in the year 2022. Now the order passed by the ADC, come executive magistrate, my lord. Firstly, he relies on the order of the deputy commissioner, which has civil, my lord, effects, my lord. Deciding it is
That
entering.
has been set aside.
Yes, now it has been set aside, but that at that time, my lord, it was there, so he relied on that order, my lord. And then, my lord, he says, directs the petitioner, my lord, to remove the structure, my lord, which itself shows, my lord, that I am in possession, my lord. And this exercise could not have been initiated, my lord, without coming to an satisfaction that there was a likelihood of breach of peace, my lord. That is, my lord, my basic case, my lord, ground. my lord. So, my lord, I will just rely on a judgment of our High Court, my lord.
Yes. good.
This, my lord, 2013, volume 2 GLR 837, my lord. And the equivalent citation is 2012, volume 5 GLT 442, my lord.
Yes.
Yes, my lord. Here, my lord, if your lordship would come to para 20, my lord,
Para.
2020, my lord. Page number 843, my lord.
Yes.
Yes, my lord. Para 20, my lord, the provisions has been reflected, and paragraph 21, my lord. I'll just paragraph 21 and 22, my lord. Paragraph 21 at age 844, my lord. Section 45 is within chapter 10 of the CRPC with
You're reading para?
21, my lord. It's 844, my lord, page number 844.
Yes.
Yes, ma'am. Section 145 is within chapter 10 of the CRPC, which deals with maintenance of public order and tranquility. Particularly, the object of the section is to maintain law and order and to prevent a breach of peace by maintaining either one or other of the parties in possession just 2 months immediately before the report submitted by the police officer or the information regarding the dispute likely to cause breach of peace concerning the land in dispute. And not only that, in 145 proceeding, the magistrate cannot inquire into the rights of the parties so far as the title of the land is concerned. He can only decide the question of possession. And while considering the possession of disputed land in question, then the magistrate is to consider the evidence adduced by the parties in the proceeding. Every dispute between the parties regarding the possession of the land would not come within the purview of the section 145 of the code unless there is likelihood of breach of peace. And if there is no material before the magistrate which suggests likelihood of breach of peace, then the proceeding under section 145 would be without jurisdiction. It is also settled that the likelihood of breach of peace should not only be existed on the date of application, but also on the date of the preliminary order passed by the magistrate. paragraph 22, my lord. On proper examination of the subsection 1 of section 145, it appears that for initiating a proceeding relating to dispute of land and apprehension of breach of peace in and around the locality is a sine qua non. Each and every dispute of land would not attract the provision of section 145, more particularly private dispute between two individuals for which remedy under civil law is available and to come within the purview of second provision of subsection 4 of section 145. It has to be proved that the person dispossessed forcibly and wrongfully within 2 months just before the date on which the police report or otherwise the information was received by the magistrate. In the instant case, it's so and so, my lord. It is on the merits, my lord. So, my lord, basically, what is the requirement is that there should be a likelihood of breach of peace, my lord. In this case, basically, when that complaint was made to the deputy commissioner, it was only for the violation of the order passed by him, my lord. Just one more, my lord. It's only one paragraph. I will take your lordship, my lord. Paragraph 7, my lord. Paragraph 7. Starts paragraph 7, my lord. It is, of course, more particular. This is the regarding that particular. If your lordship would come to paragraph 10, my lord. 9 and 10, my lord.
Which paragraphs are you referring?
9,
Paragraph 7,
7 is not required, my lord.
Ah.
7, not 7.
then paragraph?
9, my lord,
Ah,
and 10. 9 and 10.
hmm.
Here, paragraph 9, my lord, the magistrate while proceeding further as in terms of the impugned order that is so and so, which though shown interlocutor, but in effect has determined the rights of the parties as such, as the trappings of a final order, that being so the revision petition is maintained. Paragraph 10, man. It has to emphasize that the object of section 145 CRPC is to save a particular situation vis-a-vis land, etc. That is, when there is a apprehension of breach of peace, the magistrate that is has simply to ascertain the physical without reference to the rights of the other or right to possess. Same has totally escaped the attention of the law. Otherwise, the magistrate could not have been aware of the mandate of section 145 CRPC. Now, my lord, here, when the ADC and executive magistrate has relied on the order of the deputy commissioner, my lord, he has touched upon the title, my lord, title of the parties, rights and titles, and he has never carried out any exercise to determine that whether there is any likelihood of breach of peace. On the application of the respondent number 2, that the order of the deputy commissioner has not been followed, man. It has been violated, man. He mechanically issues that order, man. Just because the DC is the superior officer, man. Nothing, man. In his initial order also, he says a complaint has been made for violation of the order of the deputy commissioner. So no exercise to determine whether there is any likelihood of breach of peace, my lord. And then he has decided by now the portion of the deputy, of course, it has now been set aside, my lord. But at that time, he relied on that which entered into the rights and titles of the parties upon the land. And the order itself is contradictory, my lord. When he says, when he directs me to remove the structure, it shows that I'm in possession.
Okay.
That is all.
excuse me for 5 minutes. You're for the response. Yes.
My lord, can you turn to page 35?
Page
35. Now, this is a letter where I have intimated the deputy commissioner that my lane has been encroached upon, my lord. This is my case, my lord. In fact, in 2004, my lord, that particular lane was sold by the petitioner to one Nika Sayam. Thereafter, my lord, that lane was gifted to me. And after 18 years, my lord, when the lane,
You are actually the some relation of the respondent number 2.
we are client brothers, my lord.
Okay. Okay. So this land was gifted to you
Yes, my lord.
by that Mr. Likha.
Lika Saya.
Likha.
Yes. And the lane was in my possession for the last 17 to 18 years, my lord. After 17 to 18 years, he files a complaint, my lord, saying that Likasa has not made the full payment, my lord. Therefore, the LPC which he has obtained, my lord, that has to be modified.
Okay, LPC is one issue, possession is the other issue.
LPC is
Whether you
the,
are in possession,
yes, my lord.
because you may have obtained a LPC, but you may never be in possession.
That's why, my lord, my lord says the complaint, my lord, at page 24 also, my lord. I have filed a complaint to the Extradition Commissioner saying that one Techitalum, the son of the petitioner, my lord, and the order is also not against the petitioner, my lord. It is against the son, my lord. Because the petitioner did not encroach upon my land, my lord. It is his son who is encroached, my lord. And in my complaint also, I have made it very specific, my lord. My land has been encroached by the one Techitalum, my lord, who is not a petitioner here, my lord. May I read it, my lord? Okay. In fact,
This Techi Murki
Techimurki is the petitioner, my lord.
is the present petitioner.
Yes, my lord.
Yes,
But then my land has been encroached by one Techitalum, Tara. My lord.
Techi Talum
Yes, my lord.
is the son of Techi Murgi.
He has encroached upon my land, my lord.
Okay, that is. Okay. Yes,
And if my lord, peruse the impugn order, my lord. 18, page 18. My lord has already perused it, my lord, but then again, if my lord turns to page 19, the operative part, my lord. The last paragraph. Now, on page, last paragraph, my lord.
Yes.
Page 19. On perusal of the records, it has been found that the deputy commissioner White ordered number so and so dated 11/1/2023, wherein the application of Techimurki so and so for modification of LPC of Sri Lanka White so and so was rejected on the ground that the final cost value of the land has been paid by Likasaya. And claiming of the plot of land after 18 years of physical possession by city seems to be illogical. The land deputy commission, the DC court, well, dismissing his representation, has also advised the complainant that this Techi Murki is at liberty to approach the appropriate court for his grievances, meaning thereby that he can approach the civil court, my lord. From records, it also found that while order that is so and so, the extradition of Nahalagan has directed Techi Talum Tara, who is the son of the petitioner, my lord, to remove the illegal erected pillars posed from the plot of the complainant within 7 days. From inquiry, And by examining the parties and the evidences adduced by the parties and as per the records available and being satisfied by due inquiry had thereupon, without reference to the merits of the claim of either of the said parties to the legal right of possession, but that the claim of the actual possession of Sri Kanjal Kaur is convincing. I so decide and declare that he is in possession of the said land located at A sector Nahalagan and entitled to retain such possession until ousted by due course of law. And Sri Techi Talum Tara is directed to remove all the structures whatsoever constructed, erected inside the disputed land within 1 month from the date of receipt of the order and do strictly forbid any disturbance.
This order apparently shows that the petitioner is in possession.
No, my lord.
That is why he has been directed to remove all the unauthorized.
My lord, the position was, it was under my position, my lord. A wall was built over, my lord. They have encroached upon my land, my lord, and they have dismantled the wall, my lord.
So what about this observation to remove all the structures whatsoever constructed there inside the disputed plot?
Yeah, thereafter, they have constructed the fencing, my lord, to the fencing wire, my lord, in my lane, my lord. And this order has been directed to Techi Talum, my lord, not to Techi Mugi, my lord.
No, that's all right.
Whatsoever, my lord, since the dispute is regards to the title and the position, my lord, it is a matter of civil court, my lord, that I agree, my lord. And whether the executive magistrate has the powers under 145(1).
They do have the power,
They do
but
have the power.
the procedure prescribed has to be followed.
Yes, my lord, therefore, my lord mechanic 145. my lord.
Yes.
Whenever an executive magistrate is satisfied from the report of a police officer or upon an information that a dispute likely is caused to breach of the peace exists concerning any land. Now, my lord, here there are two aspects, my lord. Is satisfied from the report of a police officer, my lord, or my lord, upon other information. Now, here is a case where I have filed a complaint saying that my land has been encroached. But it might not be a police report, my lord, but I have filed a complaint to the executive magistrate. It comes under the purview of other informations, my lord. Since he was duly informed, and it was upon his decision whether there will be any breach of public tranquility or not, my lord. And as my lord is well aware, my lord, that order passed by the deputy commissioner, my lord, that has been to the extent where the monetary transaction is concerned, my lord, that has been set aside, my lord, partly set aside, my lord. But again, that that order, my lord, the parties are requested to go to the civil court, a proper civil court, my lord. Therefore, my lord, since that part has been set aside, my lord, I don't find any impediments in this impugn order, my lord.
Yes.
Yes, that's all, my lord.
Yes, Government.
Yes, Your Lordship, I have a limited submission on the legal aspect of 145, Your Lordship. The 145 proceeding, Your Lordship, to trigger 145 proceeding, it's a discretionary power of the executive magistrate. And upon the subjective satisfaction, Your Lordship, not on objective one, on the subjective satisfaction, the magistrate can initiate 145 proceeding. And here in the case, Your Lordship, a complaint has been filed which clearly shows that they are likely to cause breach of public peace. And basing on that, 145 proceeding has been drawn by the executive magistrate, wherein opportunity to all the parties has been given, Your Lordship. It's not a case that ex parte order has been passed. Here, Your Lordship, in the page number 19, Your Lordship, sorry, Your Lordship, page number 18, Your Lordship, in second para, the learned executive magistrate has clearly reflected that the parties involved in the dispute were called upon to give in written statement of their respective claim, meaning thereby they have been given ample opportunity. Here, they don't have a case where in violation of national justice, the order has been passed. The procedure has been duly followed, and in operating portion, Your Lordship, the learned executive magistrate has decided the possession and directed not the present petitioner, the other person, that is Tesi Talum Tara, to remove the structure, Your Lordship, whatsoever. But possession has been decided. Now, Your Lordship, here at this stage, if the monetary transaction comes, the monetary transaction which was purported to be happen between the parties, Your Lordship, it will have direct impact on the title. And for that, they have to approach the civil court.
We are not giving that direction. We are not giving direction to let the petitioner or
Yeah,
respondent.
That is why I'm saying, Your Lordship, that portion is sub judice now, Your Lordship. Now, so far as possession is concerned, Your Lordship, it has been decided by the executive magistrate. Executive magistrate has not decided the title. On the basis of the, Your Lordship, opportunity and the inquiry conducted by the executive magistrate, he has decided the possession in favor of the present respondent number 2 and directed not the present petitioner, Sri Techi Talum Tara, Your Lordship. This order is impugned to him, not the present petitioner, Your Lordship. Now, before this court is Techi Murki, Your Lordship. And there is no any authorization and such given by Techi Talum Tara to approach this court, Your Lordship, to challenge this impugned order.
Order was passed against.
Against, Your Lordship, Techi Talum Tara. It's page number, Your Lordship, 20, Your Lordship.
Techi,
Yes, Your Lordship.
Techi Talum Tara.
Tara, yes, Your Lordship, is directed to remove all the structure whatsoever. And the present petitioner is Techi Murki, Your Lordship. He ought to have, if suppose he has agreed, then he would have approached this court, Your Lordship.
Yes, that is a very substantial point.
My
Who
lord.
is the petitioner? Let us see.
Petitioner is Techi Murki. And otherwise, if your lordship would come to the complaints of the respondent 2, my lord, it is very clear. If I'll take lordship to the complaint.
Techi Talum Tara
Tara,
is your
my
father.
son, my son.
Okay, and the original owner of the plot of land is Techi Murki.
Yes, madam. I am the owner and Techi Talum Tara is my son, madam. And all along, my lord, in the complaint also, my lord. Complaint filed by respondent number 2 also, if your lordship would come to page 35. Madam. It is being complained by, alleged by the respondent number 2 that these are all being done by me in my presence, madam. I am all, my lord, but although these are my agents, my lord, basically my son, my lord, but it is my action, my lord, which is being, if your lordship will come to page 35, the complaint, my lord,
Yes.
it will also clarify, my lord.
What, again, what is this? Techu Murki, son of, oh, Techi Tikli. I'm really confused with the names.
Mhm. Techi Talum is my son. Now, my lord, if you also will come to page 20,
Techi Talum is the son of Techi Murki.
Murgi, my lord.
And this order has been passed against Techi Talum.
My lord. Although it's his name
And
is there.
you
Yes.
are coming instead of your son.
No, my lord. Basically, it is, if you also would come to page 24, my lord. First complaint, my lord.
No. Let me just forget about the complaint. Let me know the facts.
Yes.
Who is who? So Techi Murki is the father of Techi Talum,
Yes, my lord.
correct?
Yes, my lord.
Yes, the order is passed against your son.
My lord. No, my lord. would-
Why are you here? Where
No,
is
that's
your
why, my
son?
lord. That's why, my lord, I will take your lordship to the first complaint, my lord. It,
No. Let us forget about the complaint. Let's
No.
keep that aside. The order is passed against Techi Talum.
my lord. My lord, that basically, even if, my lord, let's for assume, my lord, that direction is given to Techitalu, to my son also. Even then, my lord, but the portion where the magistrate comes to the finding that respondent number 2 is in possession, my lord, that affects me, my lord. Even though direction might have been given, my lord. I'm not only challenging a particular line, my lord, a particular 2 lines of the paragraph that this direction has been given to my son, my lord. I'm challenging the order as such, my lord. And the order says the respondent number 2 is in possession, my lord, which is not true, my lord, and without following the procedure of law, my lord. All along, my lord, the proceeding also, your lordship will see, my lord. And the complaint, that's why, my lord, I was
Okay,
taking.
okay. Let the government comes to.
Yes, your lordship.
Yes.
And your lordship, even in the complaint, the annexure 4, your lordship. Here also, your lordship. Page number 24, your lordship.
Annexure,
Annexure 4, your lordship.
page.
24.
Yes.
Here in second para, your lordship, today while visiting the said property, I was shocked to notice that one Mr. Techi Tolum. Here also, your lordship, son of Techi Murki, resident of so and so, illegally entered inside of my plot and started construction of fencing posts inside the compound without my consent. My plot is already covered with boundary wall in all pole side. Here also, your lordship, in complaint also, his name is there. Not the petitioner name. Petitioner is only being a father. His name is there to represent Techi Talum, your lordship. Now, your lordship, the maybe present petitioner may have
We are
the
dismissing your petition with liberty to file afresh.
No, my lord. My lord, I will take your lordship to how this issue started. Your lordship is similar complaints, my lord. The first,
The order is, just forget about your submission. The order is passed against Mr. A. Mr. B comes.
no, my lord,
Where is your locus?
my lord, this entire proceeding was between me and this respondent number 2 only, my lord. Although that's why, my lord, that the order passed by the deputy commissioner is between me and Likhasaya, my lord. And that order, my lord, page 35, page 30, my lord, order,
You are not impugning that order.
my lord. Yes,
You are
I'm not-
actually
I'm not- I'm
impugning
not-
the order passed by ADC.
I'm not impugning those
And
orders.
ADC's order actually directs your son.
My lord, that direction might be to my son, but the decision has been made, my lord. Certain order has been passed saying that the respondent 2 is in the position, my lord. And if your lordship would see it, that page 39, my lord, the order, my lord. The initial order, if
I
your
will
lordship.
be
will come-
committing a wrong. I will be committing a wrong if I take up your petition.
My lord.
I will be committing a wrong if I take up your petition.
No, my lord. But
Yes,
that's why, my lord,
Your impugn order is not against you.
my
It
lord,
is against somebody.
no, my lord,
And
this-
somebody has not authorized you. You have no authorization letter.
no, my lord. My lord will come to page 35 first, my lord. If your lordship would come to page 35, my lord.
We are disposing your petition with liberty.
No, my lord. My
Yes.
lord, that's why I'm saying, my lord. If your lordship will come to page 35, my lord. This complaint, my lord. Subject so and so, order so and so, case number is so and so, my lord. Tichi Murgi, my lord, versus Sri Likha Sayama. After this, the proceeding was initiated, and now the initial order passed by the ADC, my lord. Executive Magistrate is at page 39, my lord. It's at page 39, my lord. This is also copy was given to me, not to my son, my lord. This proceeding is entirely against me only, my lord. That complaint was against me, my lord. And
No, you may have a good submission, but the record shows that a impugn order was passed not against you.
no, my lord,
That is passed against somebody.
that particular one order is there, one line is there, my lord. But the proceeding is against me, my lord. The orders copies were also to me only, my lord. Not to my son, man. That complaint also filed by the respondent number 2, man. Respondent number 2 complaint is also that in my presence, my son has done this and that, my lord. If your lordship will, come to paragraph 13, my lord, of that complaint at page 37, my lord. I'll try to convince your lordship, man.
I may not be convinced if the record speaks otherwise.
No, man. Because why I'm saying so, because my lord, the proceeding is,
Karanzal Khole.
yes, the proceeding
So,
is,
so to my others, so Karanzal Khole has actually in the complaint filed to the deputy commissioner stated that Techi Talum,
this is, my lord, intimation regarding deliberate violation of the order dated so. and so.
Techi Talum started to encroach upon the said plot of land.
That was the first order, first complaint. If your lordship come to page 35, my lord.
I'm on.
Yes, my lord. That is regarding intimation regarding deliberate violation of the order dated so and so, and to initiate necessary action thereof. So reference is so and so, Tichi Murgi versus Tichi Saya, my lord. So Tichi Murgi is here, my lord. And the contents of the complaint, my lord, paragraph 13, my lord, all along, my lord. The respondent number 2 says, it is being done in my presence, my lord. So basically, I am old, my lord. I cannot carry out the physical activities. And now, my lord, this case was not against my son. If your lordship will come to page 39, my lord. Copy 2, my lord. If your lordship will see. Down below, copy 2, my lord. It's not my son, my lord. It's against me only, my lord. Tichi Murgi, my lord. And the impugn order is also, my lord. Is also,
Against,
yeah, my lord.
against your son.
Yes, ma'am. There's a particular line is there to remove the structures, my lord. That is to my, that direction has been given to my son, my lord. But when the ADC, my lord, has come to a finding about the possession, my lord, it affects me, my lord. And my initial ground is even not talking about the direction to my son, my lord. He could not even have started this proceeding, my lord, without a satisfaction, my lord.
No, we are not on the married. We are not unmarried. We are not unmarried.
Well, I'm only on the legal
We
issue, my
are
lord.
just on the order
My lord.
which is passed against a particular person. And it is not that person, but a different person who is before this court.
No,
So
my lord,
if
if your
this
lord,
court is to take up this matter, then I may commit wrong.
your
I'll be
lordship,
committing wrong.
Lordship would see, my lord, that particular direction is there, but otherwise, this case is against me, my lord. Direction has been given to my son, my lord. In other words, may I pray, my lord, that this may be listed again, my lord, so that I'll try to, my lord, convince my, your lordship, my lord.
Why don't you come up with a fresh petition? We are giving you that liberty. What is the difficulty? Just adding one name?
My lord, because that my son was not a party, my
No,
lord.
no, no, no. Your son is not a party, but the impugn order is against your son. And your son is not before this court.
No, my lord.
So when impugn order is passed against Mr. A,
No,
if Mr. B comes to court,
no, my lord.
whether it'll be proper for this court to take up that matter?
No, my lord, that order, particular direction, it might be there, my lord, but this
It is there, not it might be. It is there.
yes, my lord, it is there, my lord, but the factum regarding the possession, my lord, it affects me, my lord. And this case is against me only all along, my lord.
You are an old man now. Your son is the boss of the property.
No, my lord, I am still the boss, my lord.
You were actually saying that your father is now old, your son is taking care of all the
No,
property.
my lord, it is done, it's being done in my presence, my lord. Although
So-
that,
We are disposing with liberty.
no, my lord, then let it be listed some other time, I will come with necessary application for further, my lord, to rectify this thing, my lord. That my lord may give that liberty. Give me some time then.
Under which provision of CPC you can come as a.
CRPC, my lord.
My lord, yeah.
Because
My lord, if that be so, my lord, there is an interim order, my lord. The interim order may be vacated, my lord.
no, my lord, that he has not come with any application, my lord.
Interim
Because,
order
my
will be
lord,
vacated.
Here what I'm saying, my lord, that direction is there, my lord, to my son, my lord. But the case is against me only, my lord.
I have understood.
Because the initial order itself, the inception of this case, section proceeding under 145, my lord. The order at page 139, my lord.
That's okay. That's okay. It's under
Yes.
145. And
Yes,
then,
my lord.
the provisions contemplated under 145 has to be followed. What this court is on is that actually the person against whom the impugn order has been passed is not before this court. That is the issue.
No, my lord, if your lordship will see, my lord, it's the last portion is that Trichy Talumtar is directed to remove all the structures whatsoever, my lord. That direction is there, my lord. But the fact that the respondent 2 is in possession, my lord, that affects me, my lord. That affects me, my lord.
This is a small thing which you should have taken care.
Because the case is against me only, my lord. Proceeding, the 145 proceeding is against me and the respondent number 2. my lord. In fact, that direction, my lord, whether the ADC could have given the direction or not, that is one issue, my lord. But when he have decided that the respondent number 2 is in possession, my lord, it affects me, my lord. It is not that the order,
You come up with a fresh petition. What is so difficult for you?
because my lord, that my son has never been, the case is against me and respondent number 2.
No, the complaint is that your son has actually encroached the land and has made some illegal construction on the land.
Yes.
So,
Yes, my lord, the
complaint
complaint,
is against you,
complaint,
against your son.
no complaint,
And the order also is passed against you, against your son, I'm sorry.
my lord, that case is, my lord, otherwise that content of the complaint also your lordship will see at page 35, starting at page 35.
If you don't want to withdraw and file this thing, I think I may not be able to take up this case.
That's why, my lord, then your lordship may grant me some time, my lord. Because, my lord, that complaint is, in the complaint itself, it says, in my presence, this is being done, my lord. In my presence, my son is doing these things, my lord. And so long, all along, my lord, every proceeding, my lord, it is between me and the respondent, my lord, not my son, my lord. So even if in this order, my lord, the direction has been given to my son, my lord, his finding that the respondent number 2 is in
The
possession.
more you submit, the more I'm not convinced.
My
What to
lord,
do?
may I pray, my lord, then just a small prayer, my lord. Then let it be listed, my lord, next week, my lord, that I will try to, my lord, find out something, my lord. Just give me that, your lordship would give me that opportunity.
May I please, my lord?
Yes.
My lord, my friend was the one who insisted for disposing of the case, my lord. I was not, in fact, if that be so, my lord, there is an interim order, my lord. And I humbly pray, my lord, they are harping upon the interim order, my lord.
What is the interim order?
That,
Status quo?
no, no, no,
Or what is it?
this has been state, my lord, the
Imperial
order passed by
has-
the,
Imperial
because
has
there is
state-
a direction from the executive magistrate to evict the encroachers, my lord, Techi Talun Thara, my lord. Now, since that order has been state, my lord, so it will be treasurized to me, my lord.
I'm only asking for next week, my lord, so I will.
Give it back.
Yes,
Let us see what happens. Because actually, if he does not want to file a fresh petition, pleading the person against whom the interim order is passed,
Oh, my lord.
maybe, though I wanted to dismiss with liberty to file a fresh, still then.
I'm just doing my duty, my lord. I'm praying for vacation of the district, interim order only, man. It will be listed next week, my lord. We can hear it.
Next week, my
I
lord.
don't.
Listed again next week. But maybe this issue may always arise.
My-
This
Right.
issue may always arise.
Always. And it's punishable if suppose the order is not complied with, that person will be booked under IPC, not the father.
So you take steps immediately.
My lord,
How
I
to
will-
cure your petition,
Of course, my
okay?
lord.
Maybe I thought that we could at least dispose of this case, but unfortunately. Take care of your.
My lord, my lord.
Like that.
Yes.
All right.
That interim, my lord, that it may be extended till next week, my lord, at least.
Okay, let
Oh,
us
no,
be.
my lord.
The interim order passed earlier. Shall continue till the next returnable date.
Always.
Yes,
My lord, on behalf of the Komni River.
on behalf of
Land Council for Komni River. He's sick today.
the council for the,
Komni River. No, I'm behalf Komni River. Land Council Komni River. He's sick today. my lord.
the council for the
Yeah.
petitioner
Petitioner,
respond.
petitioner.
Oh, okay.
Your Honor, my lord, the matter may be listed after 3 weeks.
Okay.
My lord, interim order may be continued.
You are mentioning on behalf of the council for the petitioner,
Yes.
Mr. So-and-so
RD Bhavin.
makes a mention on behalf of Mr. So-and-so. The learned counsel for the petitioner. And seeks adjournment of the case for 3 weeks on the ground that the learned counsel for the petitioner is indisposed. Prayer is allowed, listed after 3 weeks. Okay.
May I please, your lordship?
Yes, please.
My lord, item 5 and 6, they're arising out of the same FIR.
Item 5 and 6.
Yes.
May I please? I'm appearing for on behalf of victim.
Okay.
Lordship,
This is the PP.
PP.
Yes, yes.
You're appearing on behalf of
Victim
Oh, victim.
to assist the PP.
Okay.
Lordship, the FIR is at page,
What is, anyhow, tell me the gist first.
Lordship,
Tell me the gist of the case. What is the gist?
there is a shop in which the petitioners had gone, and the complainant who was near the shop, he was asked, have you, there were two people. One of the accused person asked the person, have you seen him, my friend? Then he got offended, then why have you called me bhai? And then they started fighting. Other people also join in, then there was a sort of a group fight. But the allegation is that that we have the accused persons have used the dao, and therefore there is a grievous injury. That is the only thing, Lordship. FIR is at page 13, Lordship.
Yes,
Operative portion is.
yes, case diary with the injury report.
Yes, Lordship.
Let us see. Where's the injury report? Is it here?
Lordship, it's last page, Lordship. The injury very severe, Lordship. Operation also need to be done, Lordship. The injury is so deep that it's affect the skull also. The photograph of the skull is also annexed in the last part.
What is the MLC report? MLC?
Lordship, there's a medical report, Lordship. There's X-ray and all, Lordship. As per the report, Lordship, they,
This is anticipatory.
Yes, Lordship.
Why don't you surrender before the police?
My lord, of course, I have not seen the injury report, so I don't know what is there, but so far as I am aware of the incident, it should not be under 326,
No,
Lordship.
it's very
Because-
grievous. It's very grievous.
Lordship, just a heart does not necessarily mean grievous hurt unless it comes under.
You have actually tried to chop the neck, you have inflicted the injury with on the face and all this.
Lordship, they would come under section 324, Lordship. Because
no,
At
under,
this juncture, we are
Lordship,
not concerned.
if I try to chop the neck, Lordship, it may come under 324.
We have in fact.
Because if I actually chop the neck, then if he dies, murder, of course, but otherwise, since it's privation of the body part, then it would come under 320, Lordship. Now, Lordship, if just saying an injury is grievous, it doesn't make it grievous, Lordship. It should come under the definition of section 320, Lordship.
No, we are not on that now at this.
Lordship, because
We are not on that.
because the section, Lordship, we should be discussing this, Lordship.
Why are you trying to abscond? Why don't you at least submit before the police? Give your statement.
Lordship, I'm not trying to abscond, but Lordship, because it was a simple fight, it should not have come to this, Lordship. Whatever in,
Simple fight which resulted in serious injuries.
so Lordship, they were attacking us with stones and sticks, Lordship. That was a private defense, Lordship. In any case, Lordship, this would come under under the section 324, Lordship, not under
We are
326,
not
Lordship.
concerned, because this is not trial, so we are not concerned.
Yes,
whether section
yes, Lordship,
320
but the injury should be such that it should come under the definition of grievous hurt under section 320, Lordship. If it is not, then it would come under 324, Lordship,
Lordship.
which
I-
is a bailable offense, Lordship.
You want to save your client, that's why you are pulling in section 324.
No, Lordship, of course, Lordship has to see whether that comes within the definition of grievous hurt, Lordship.
It was a regular bill,
No, Lordship.
but it is anticipated.
Of course, it's up to you, Lordship.
You surrender. Yes,
Lordship, this is, comes Lordship is 326 only because voluntary causing hurt by dangerous report or means Lordship. Here, Lordship, the injury is in such a place that it can cause death. It's a neck, Lordship. You can see Lordship in the photograph also. And also injury is so severe that it deep inside his skull also he got some injury, Lordship, and that need to be operated in the and his condition is still not stable. And Lordship, more about Lordship, the statements of the witness, Lordship, it is corroborated with the statement of victim as well as the complainant. So there are a number of witnesses also there which have this statement of these witnesses have already Lordship annexed in the CD, Lordship. So Lordship, there's every Lordship possibility, Lordship, if they have got a bail, Lordship, they will hamper the Lordship investigation process. So Lordship, this is not a fit for fair case for the
The public prosecutor may be asked whether the complainant, how many days he was in the hospital? If that is so, Lordship.
Lordship, complainant Lordship is the one of Lordship,
That
this
question may be
is
asked.
also a victim, Lordship, but the main victim is still in the hospital, Lordship. And complainant also he got some
Whether or not it
injury.
will come under section
And Lordship,
326 will be
these two-
dependent on that fact,
These
Lordship.
two Lordship, accused Lordship,
Because there is no
One-
privation of any body
one is
part.
already Lordship as habitual offender and the other is the one who have attacked that night with the sharp weapon. And that is only mere one word, Lordship, that he called, who called him them by Lordship. It's out of that. No, it's a very Lordship kind of Lordship. Their intention is like that, Lordship. They want to kill that person out of that minor one word.
there's a complainant and the injured, they are brothers.
No,
Lordship, they are just a related, Lordship.
No. Oh. One is a brother and one is friend, I think.
Lordship is a relative, Lordship, not a Lordship. As per this FIR, Lordship.
No,
it is
Lordship,
stated.
the public prosecutor may be asked, how many days he was in hospital?
Complete.
Yes, the
Complainant.
victim, the alleged victim.
Victim is still in hospital, Lordship. He has not recovered well.
Where is the document to show that? If it is in the records, then I will,
Because lordship, here lordship in the.
if it is an indoor patient for more than 20 days,
report text,
then I
lordship,
will,
reveal, it revealed that this further.
Yes, what does the injured says, the victim?
Your Lordship, I'm severely injured with multiple,
Where are you now?
I am now under treatment also
Where?
in the, not in the hospital, but in the clinic. I am advised for the operation in my skull of my this face still. And I'm not, I'm still in trauma out of this incident. I'm not coming, I'm not stable now. Mentally, physically, still not recovered, Your Lordship. And moreover, Your Lordship, this alleged accused person in the item number, next item number, Ram Plago, he is holding the post of president of all Arunachal Pradesh Border Student Union. He is very influential person. If at this stage he is granted bail, interceptory bail, the investigation may also be hampered by him also. So I have a strong objection of granting, and such a criminal is not deserved for the.
If he is an influential person, it means that he is deeply rooted in the society and the chance of his absconding the process of law is slim.
Is the habitual offender also.
That the law will take care.
At this stage, Your Lordship, that bail may not be granted. Since I am still not coming out of my this incident and my injuries, severely injured in the back side also, here neck, in the neck also, in my knee also, cut injury of this dangerous weapon. Luckily, I am saved from their clutch. Otherwise, I would have been choked out. My neck would have been chopped out. Luckily, I am escaped. Now I am alive. Just for a simple minor word, also. Just only who called me bhai. Bhai means younger brother. You cannot call me younger brother. Out of this word only he started attacking me. Nothing words, no any such unparliamentary words, nothing was used. Only just please buy, and only that word only. He got angry. Intention, Your Lordship, intention is that he, during fighting, one Ram Flago was holding my hands, and this Malo Plago, he went to his car and took out the machete, this dao. And the intention is very clear, to kill me. So grievously injured.
Okay. So, but the victim is not included as a part.
oh yes, Lordship. Actually, Lordship, my other colleague was appearing earlier in this matter. So I was not even aware of this. Today is gone somewhere, so I have to,
Include and come.
Lordship. Since he's already here, Lordship,
But they have not included. Whom is he representing the victim, which is not a party?
Lordship, in that case, I'll implead. Maybe taken up after a week.
We'll listen tomorrow.
Lordship, actually, I,
Complete this,
Lordship,
we can direct the.
my other colleague who was appearing in this case, he's out of station. And tomorrow, actually, Your Lordship must have heard, there was this very bad case of rape in a school in Al Monigo. In that case, I'm appearing in the Sessions Court as a legal aid counsel, right by this court. So that is why, Lordship. Lordship, on 28, Lordship, I think he should be back on 28. In the meantime, I'll ask my other.
Till 28, you will abscond the law.
Lordship, actually, I'm not in touch with the accused persons. I have no knowledge.
Lordship, it's a very fit case for rejection, Lordship. They better they surrender before the IR and Lordship give their statement.
Okay, heard your good name,
And Duncan,
so and so. Learned counsel for the applicant.
El
And
Hage, this is the public
MS
person.
Elagi, the learned PP for the state of Arunachal Pradesh, and Mr. For the victim, namely,
For the victim,
namely,
victim, Pagyum, my name is Kega,
no, I heard Mr. Chandra, for the victim,
victim Pagyum Salam,
ma'am, you got it? Pagyum.
Pagyum Salam.
Okay, let me apply my mind, let me not,
Lordship, Lordship,
Can I-
kindly keep the city with you, Lordship, and.
yes, I'll give you back.
Lordship, much
Okay,
obliged.
let me apply my mind, let me pass this.
Lordship, only one submission, Lordship. If if it doesn't come within the definition of grievous hurt in the case diary, then Lordship 324 would apply.
Ma'am, anticipatory bail, where is the question of examining all those,
No, Lordship, it should be on the face of it. It would depend on the injury report, whether or not the injury is grievous or not. If it is grievous, then 326. If it is not grievous, then 324, Lordship.
we'll pass the.
In that case, Lordship, 324 is bailable, Lordship.
Okay.
Lordship,
Obliged.
Thank you. In the chamber. Yes, sir.
Please, Lord.
Yes.
This is a motor accident claim appeal. So
What is this, IA for?
IA for condonation.
Oh,
While filing this appeal, there were 39 days delay. That's why for granting the delay condonation, this is IA. Delay is reasonable, your lord.
Who is the respondent?
Respondent is the
Miss-
sole respondent. Sole respondent,
Miss Tenzing.
yes,
Why,
Mr.
why only one respondent?
One respondent.
She is the
because-
vehicle owner,
Yes,
vehicle owner,
no,
or
the deceased, her father was the deceased and she was the injured person. So her father, item number 7 and 8 are analogous matter, my lord.
okay.
Yes,
Yeah.
so she is the only sole respondent here. The question is that,
Okay, okay.
Yes,
The applicant is the
Yes.
insurance company.
yes, yes. So we are the insurance company, United Indian Insurance Company. The condonation may be granted, Lord.
Mr., your good name, please. Your good name,
You take a.
so and so. The learned counsel for the applicant. The present application has been filed under section 5 of the Indian Limitation Act 1963 for condoning the delay of 39 days in filing the connected MSC appeal, in which the impugned judgment and award dated 24/5/2022 passed by the learned member, Motor Accident Claims Tribunal, Bondila,
Yes,
has been challenged. Where is the ground?
my grounds are para 6, my lord. Para 6. 5A,
Para five.
para 5A, my lord. So may I read my lord? The humble applicant received the impugned judgment and award dated 24/5/2022 in the first week of June 2022. After receiving the said order, the applicant forwarded the same for legal opinion from the senior standing counsel at Guwahati.
Yes, okay.
Yes.
The grounds explaining the delay
Yes, yes,
has been set out in paragraph 5 of the application.
yes.
Stop. This court on perusal of the same is satisfied that the applicant has satisfactorily explained the delay. Accordingly, the delay of 39 days is condoned. Is condoned. Stop. This court has also seen the office note dated 24/8/2023. Which reflects that the AD card received after duly service of notice in respect of the sole respondent. What is this? The AD card received, okay, just, this is not repetition. Okay? The AD card received after duly service of notice. The AD card has been received after service of notice upon the sole respondent. Okay? Stop. The application accordingly stands disposed. Where is your main? Man? There's a main appeal, okay, man? In view of the order passed in ISC 206 within bracket AP of 2022. The appeal is admitted, listed for hearing. Okay. The same with the next
Yes,
item?
same,
The
my
same
lord.
with the next item?
Same analogous matter. My lord.
Yes.
May I please, your lordship?
Yes.
My lord, in respect of respondent number 2, my lord, service report is still awaited, my lord.
Item 9.
My lord.
Item 9.
So, my lord, may I pray that matter may be listed on 29 again, my lord. We have already taken the steps upon the respondent
Upon
number
respondent number,
My lord, I am
What is-
available for the.
okay, upon respondent number 2,
2.
you have a serve notice.
Okay, my lord, now the council is appearing on behalf of the respondent number 2.
Okay, okay. Yes, okay. Respondent number 2.
My lord, this application is prepared by the applicant for, my lord, the cancellation of the bail granted to the, my lord, the accused person, respondent number 2 here in, my lord, in such a serious POCSO case, my lord. My lord, almost I'm half on my way of submission, my lord. Lordship has already seen the order passed by the land court below.
Stop. Office note dated 22/9/2023 reflects that service report in respect of respondent number 2, not yet received. Awaiting service report, awaiting a return service report listed after 2 weeks. Stop. In the meantime, the learned PP is also directed to produce the.
Updated city. Updated city.
Pardon?
Updated city.
Updated.
Updated city.
Updated status.
Yes,
Updated
during bell
status.
time, it was called for
Updated.
Case diary.
CD, case diary.
CD, okay, updated. CD. Listed
Oh.
after 2 weeks. Yes, please.
May I price, Lordship? Lordship, this is an application under 482 for quashing of FIR. And my lord, here, charge sheet has not yet been filed. Your Honor,
Where is the Misty Ginny? I think order dated 9/8/2023 communicated to Mr. T Ginny,
Misty.
Miss T Ginny, additional PP for AP. What does it say? Who is the, only the state respondent,
yes, my lord.
no other respondents? Oh,
My lord, this is joint petition filed by both the complainant and the accused.
so this case is handled by Miss T Ginny.
Yeah, I have no brief, so I have no idea. Miss T. Ginny is, because of his personal difficulties, he could not attend today.
Miss T Ginny. They learned additional PP
Yes.
for the state. He is absent. So listed after 2 weeks.
Obliged.
Yes, ma'am.
As for the last order, my lord, I have taken the step upon respondent number 2, but as for the office note, it's so that ID card is yet to receive.
MS Censor, Learned Counsel for the petitioner. Awaiting return service report from the respondent number 2, listed after 2 weeks.
Obliged. Your Honor, on senior counsel is in another court, as so for timing, this matter may be passed over.
The Mr. Who is the
Aringo,
Mr. So-and-so? The learned counsel for the petitioner is on his legs in court number 1. So let's discuss after a week.
much of them.
May I, my lord?
Yes,
My lord, this matter may be adjourned today and this may be fixed on 13th November 2023.
why so long? 13 November.
My lord, as a request made from the respondent,
You are the counsel for the respondent?
I'm for the petitioner on behalf of Enderton.
Why you should take undue advantage? He is not there.
Yes, he has requested me to take on 13th.
So you are the counsel for both the petitioner as well as the respondent. Okay, take a short date, 2 weeks. Because 13/11, I think it's. After 2 weeks, you can mention that, okay, again.
Okay,
On the prayer of the learned counsel for the parties. Listed after 2 weeks, okay?
much obliged.
Yes. Yes, please.
This appellant is not seen today.
There is no representation on behalf of the appellant. Mr. So-and-so,
Jitado,
Jitadu,
Jitado.
Jitadu, learned additional PP appears for the state respondents, listed after 2 weeks. Yes. This over. This one, another? Another? Is that?